All right, Chair, we're live.
Thank you. Good evening, everyone. Welcome to the January 2021 edition of the State Joint Commission on Public Ethics. Thanks, everyone, for joining us today. As with all JCOG meetings held during the pandemic, we are once again using video conferencing technology. The public session is accessible on JCOG's website to watch via live stream. As a reminder, it's important that only one person speak at a time. In addition, I ask that when you speak, you identify yourself so that we have a clear record. We will take votes by a modified roll call, as we've done in the past, to ensure that everyone is counted. Please remember to mute your phone when you are not planning to speak. Behind attachment A, we have the minutes from the last public session in December of 2020. Any comments or questions?
Chair, this is Monica. I have an edit.
Go ahead.
Okay, so on page 4, the 4th paragraph that begins Commissioner Weissman. I don't know about everybody else, but I hear a lot of feedback. So anyone who's not speaking, please mute your phone. The paragraph that begins Commissioner Weissman would like to add, stated that the First Amendment argument was a red herring, comma, and then continues, suggested a staff review.
Okay, anybody have an issue with that? I mean, that's fine with me. Any other questions or comments?
Mr. Chair?
Yes.
With that change, I'd like to make a motion to adopt the minutes.
Thank you, Commissioner. Is there a second?
Commissioner DePiero, second.
Thank you, Commissioner. Martin?
Yes. On the minutes, all in favor, please raise your hand. Let's see, 1, 2, 3, 4. I see Commissioners Yates, Fisher, Weissman, and Rosen. I'll call the remaining roll. I'm sorry, Commissioner Deering, you came in and out. Did you vote in favor? I'll keep going. Commissioner Deering. I think we're having issues there. Commissioner DePiero.
Yes.
Commissioner Jacob.
Yes.
Commissioner McNamara.
Yes.
Commissioner Cohen.
Yes.
Commissioner Levine.
Yes.
Judge McCarthy.
Yes.
Commissioner Jacob. Oh, I already got you. I apologize. And I'll go back. Commissioner Deering. Try one more time. Okay.
Martin, I saw him raise his hand in favor before.
Okay, great. So that's 1,
Okay.
2, 3, 4, 5, 6, 7, 8, 9, 10. All right. Motion carries.
Great, thank you. Item 3, report from staff.
This is going to be Steve Boland, Director for Administration. He'll start the third quarter financial report.
Thank you. Good morning, everyone. Cash dispersed during the third quarter was $1,096,000 for a year-to-date total of $3,622,000. For personal service, the percentage dispersed was about 70%, and for non-personal service, approximately 44%, for a total of 66%. That shows our financial acumen in terms of trying to reduce costs throughout the year. Does anyone have any questions? Thank you.
Thank you. Mike?
Mr. Chair, I will
Before
cover.
we turn, Sure. Before we turn to the operations report, Martin, you're going to report on just the proposed budget?
Yeah. The Department of Budget, or excuse me, Division of the Budget released the proposed appropriations for fiscal year 21-22. Our budget has remained flat, relatively flat, with a nominal increase of $12,000, which reflects a rent increase in our Buffalo office. We do still expect DOB to request a 5% reduction across use of cash. This would equate to about $280,000 for the agency. We've been planning for this and believe we can live within those confines.
Any questions or comments?
Chair, quick one. Hey, Martin, are we already under a 5% cap in appropriation versus cash?
Yeah, there's been a current year spending plan that was requested by Division of the Budget, which we have incorporated into the current year's spending and carrying it through to next year as well.
So this is not 5 plus 5. This is just the current 5.
Yeah, the current 5 that we've been living within.
Okay, thank you.
I have one question. This is Commissioner DePiero. Monica had mentioned in a prior meeting that we requested an additional investigator. Does this budget include financial wherewithal for the additional investigator?
Yes,
Yes.
that position is incorporated into this figure.
Thank you.
All right, if there are no further questions, I'll continue, Chair, with the operations
Yes, thank you.
update. Okay. So arising out of the work of the Confidentiality and Records Access Committee, staff has prepared a new monthly operations report, which has been distributed to the commissioners and should be posted and attached to the meeting agenda on the website. It provides the public with information about the commission's activities. So at each meeting, this is something we intend to do, and this would be provided at each meeting rather than waiting until the annual report to compile all of this data. The first report covers the month of December 2020 and some calendar year totals for the year 2020. It includes data about investigations, lobbying, and ethics, as well as other units. For example, it includes the number of 15-day letters that we would have sent in December. As you can see in the report, we did not send any in December, but that is what we would anticipate reporting each month, as well as open investigations and pending matters as of the end of the month. It also includes data on the lobbyists and clients in the system, the requests for guidance that staff has handled, FDS compliance efforts, audits, and training. The new report is just one among many ongoing efforts of the Commission and the committee to increase transparency about JCOP so the public has a better idea of the important work that we're doing on a daily basis. The changes to the records access regulations, which will be presented later in the meeting, are another initiative of the committee. The committee is continuing to discuss additional ways to be more open within the constraints of our law and plans to meet again on February 10th. So if anyone has any questions about the report, the commissioners, you should have received the latest version last night, and for the public, it is available on our website.
I don't have any questions, but I'd like to take the opportunity to commend staff. I was one of many commissioners that was interested in seeing information like this come out on a more regular basis. And I think you've done a tremendous job with it, and really would like to thank you for the excellent work.
Thank you,
You're
Commissioner.
welcome.
All right, let's move on.
The New York City office update. Just to let everyone know, the New York City office is temporarily relocating to the 28th floor, which has a different entrance. So if you ever need to come to the New York City office, you would enter it from 60 Broad Street. The move is tentatively scheduled for the end of February, beginning of March. We're waiting for a firm date. As previously mentioned, the space will have a secure area for a confidential record, and it should have a conference room that we can use for investigative purposes and meetings. The work on our new space, the ultimate space that we'll move to on the 5th floor for 25 Beaver is scheduled to be complete in the fall, but I don't know if they're on target. So this will be our space until the 5th floor is ready.
Great, thank you. All right, let's move on. Item 4, behind attachment B, the proposed amended comprehensive lobbying regulations.
I'll take that, Mr. Chairman.
Thank you.
As you mentioned, the regulations for lobbying are behind tab B as in boy, and source of funding is tab C as in cat. Just a reminder, this process is to adopt the first set of revisions to the lobbying regulations that were adopted or promulgated in 2018, as well as amendments to source of funding in 18 as well. The revisions that you're voting on today were adopted at the December meeting on an emergency basis, and they have been in effect since their submission to the state register. We are requesting today a vote on a permanent adoption. We did not receive any public comments after the last publication of the regulations. We did have some engagement recently with stakeholders, but based on the concerns they raised, we don't see a need for substantive revisions, and we'll work with them to address their individual concerns. If these are adopted today, they'll be effective upon publication, which I believe would be February 9th. And unless there's any objection from a commissioner, I believe we can handle this in a single motion on lobbying and source of funding. I'm happy to address any questions or bring in Carol Quinn if anybody. Commissioner Weissman has his hand up.
I have one question, Martin, regarding a change on page 59, where you struck the terms including a fiscal sponsor. I assume that was designed to get third party or other nefarious, I'm going to use the term loosely, money laundering schemes to get into the system of lobbying. I recognize there is no definition of fiscal sponsor. So I just want to know how staff views that it's going to be able to still enforce the regulations.
There's a couple of provisions in the regulations that we believe already encompass that situation. We thought the additional use of the term, especially without a definition, as you point out, would only create confusion without adding any additional teeth. Basically, we have provisions that provide that anyone who pays for a lobbying effort becomes a beneficial client and is thus disclosed. And there's another one in there. Carol, can you remind me what the second one is? I apologize.
Yes, can you hear me?
Yes, we can.
Okay, I'm sorry, my video is not working. But the other way it really, the concept of fiscal sponsor is incorporated is within this, just farther down on page 59, within the definition of contribution, which means the provision of funds or resources. So we think between all of that, the concept of fiscal sponsor is covered. Obviously, there always can be some bad actors, but we think that the regulations are clear enough now. And we thought the phrase fiscal sponsor was duplicative and also might cause some confusion since it's not defined.
Well, as long as staff is comfortable that we've collected all the potential nefarious ways of getting money into this, into the lobbying system, then I'm comfortable, and thank you very much.
We are, thank you.
Thank you. Other comments, questions?
Chair Rosen,
All right.
this is Fisher. I'd like to make a motion to approve the modifications to Part 943 as contained in our meeting packet.
Thank you.
So just
Second.
to clarify, that's a motion to adopt the regulations, to accept the modifications and adopt the regulations.
Yes, that's
That's
correct.
correct.
Thank you for the clarification. And if you could change the motion to reflect that, I'd appreciate it.
Thank you. And Commissioner Weissman, second? Thank you. Martin?
Yeah, I just want to find out, Commissioner Fisher, did you would you like to include the source of funding regulations, or should you handle that separately? It's completely up to you all.
Well, let's simplify it and include it unless someone objects.
Okay.
Good. Commissioner Weissman, does your second still stand?
Absolutely.
Wonderful.
Thank you. Martin?
On the permanent adoption of the revisions to Part 943 and Part 938 of Title 19, all in favor, please raise your hand. I see Commissioners Rosen, Fisher, Weissman, Deering. Am I missing anyone on video? No. Okay, I'll call the roll. Commissioner DePuy. I'll come back. Commissioner McNamara. I'll come back. Chair Rosen, Commissioner Weissman. Judge Yates.
Yes.
Okay, Commissioner Cohen.
Yes.
Commissioner Levine.
Yes.
McCarthy.
Yes.
Commissioner Jacob.
Yes.
And Commissioner McNamara once again. Okay, that's sufficient votes. The motion carries.
Commissioner
Thank you.
DePiero also in favor.
Thank you.
Thank you, Commissioner. Okay.
Okay, next set is, sorry, switch gears here. This is behind tab D, as in David, you have the proposed amended records access regulations. These are something that we discussed at the last meeting and arise out of a proposal from the Confidentiality and Records Access Committee designed to provide additional information where it is permissible under the statute. Our current regs on records access or publicly available documents mimic section 9419 of the executive law. And that provides that the financial disclosure statement itself is a public document. What these regulations would do is provide auxiliary information about a financial disclosure statement. It deals generally with information that is available regarding a specific FDS filing or filer, and it also would include title and salary information for JCOPE staff. As I mentioned, this was presented at the last meeting. The only substantive change is on page 2, subparagraph 1, B as in boy, and the proposal would provide that when a filing is released to the public, it would indicate whether information has been deleted or redacted, as the term may be used. Previously, we would have also included whether something was exempt, but we recognized there were conflicts with other regulations, as well as the notion that something that's been exempted from reporting is not actually part of the filing, and thus we wouldn't be changing anything when releasing it. So again, this comes out of the Records Access Committee, and if the commission wishes to move forward, the next step would be a vote to commence a rulemaking.
Question.
Yes, go ahead.
Since this scope and purpose that you have in 937.1 contains various exemptions, would it be appropriate to include the exemptions that arise under the governor's order to exempt pursuant to legislative authority? I forget the section number of the governor's. We have this. We'll have to go back. I apologize. It's 236. Is it point 1 and 2?
I just want to clarify because I'm
talking about the corona exemptions for filing FDSs and the like.
Oh, the executive orders under 202.6 and 7, right?
That's what I was reaching for. 202.6 and 7 provide exemptions for filers and filings of all sorts, and you have various exemptions in here. Now, we don't have those items, and we ought to say we don't have them, and that's what the other exemptions basically say. So would it be appropriate to include 202.6 and 7 in the appropriate places in this proposal?
Well, Commissioner, I think it's worth parsing out your statement, and I'm not trying to quibble with it, but the executive order, as we've discussed in the past, exempts certain people from the definition of public officer. So it's not the same as saying that they don't have to file an AFDS. It's saying that in this capacity, they are not state officers. And so there's really been no exemption awarded by the commission, which is what we are using as the basis for our disclosure of an exemption. They simply don't come to us as public officers under the law. But beyond that, that's how far the commission wants to go is a policy question. I just wanted to clarify from a legal standpoint.
Okay, but you have exemptions here under 94(9), and those are not commission exemptions necessarily, they're legislative. But, this is in fact a legislative exemption because it was authorized.
Well, again, what the executive law provides in Section 94 is a process whereby the commission decides whether to award an exemption to someone who is otherwise subject to the provisions of Section 73A. The individuals you're referring to under the executive order would not be subject to that because they are not subject to the public officers law from the very beginning. So we would not be any part of that process. What we do under 94(9)H, I, and I-1 is review an application for exemption as we are empowered under the law and then decide whether or not to award it. And these regulations would articulate whether or not we have, in fact, taken such a step. Again, what you're referring to is someone that would not come to us, and thus we would have no role in that.
Well, this is all aimed at transparency. These are all aimed at transparencies. I assume somewhere in our rules or regs or really, we should have something about these files that aren't being made, that we don't have them. They're exempt and why, but this is an opportunity. And if it's your view it shouldn't be here, I'll defer to you. I think it should.
Chair, if I may speak, it's Monica. Commissioner, I appreciate your point about being clear that we don't have those records, and there may be an appropriate place, to do that. But these regulations are about governing our records, and of our records, what is going to be made publicly available and the process for doing so. So that's the purpose of these regulations. We could talk, separately about a place to make that point, that there may be other exemptions that have been granted so we don't have records. Another example of that would be client determinations that may be made by OCA, the court administration. We don't know if client exemptions were granted. So that's another example where we don't have that information. But the purpose of these regulations is to govern disclosure of records that we do have, to clarify what is going to be publicly available and how it's going to be public available, and the procedure for challenging that. So that would be something for the commission to consider. I'm not sure that addressing records that we don't have fits into these regs.
Mr. Chairman. Yes, Commissioner, go ahead.
I have a number of questions for our able staff. First, I want to follow up on Commissioner Jacobs' observations. As I understand it, there are a group of volunteers who presumably are within the ambit of the governor's executive order, who are otherwise within the ambit of our jurisdiction because they're serving in other posts. For example, I'll just use an illustrative exemplar. Someone serving on the board of the Metropolitan Transportation Authority, who then is involved in the rollout of the new vaccines. Would this individual be partially exempt under the governor's executive order, or completely exempt, even though the person is simultaneously serving on the MTA?
So, Commissioner, as we've discussed before, the scope of the executive order is really not a question for us, but there's, on its face, there's nothing to suggest that anyone who's otherwise subject to our laws for non-COVID related duties is somehow not required to comply with the public officers law or submit a financial disclosure statement or any other obligations they have in their state capacity. It's the executive order on its face only applies to COVID related activities. I can't answer any hypotheticals. We would need all the facts, and we could address those when we have something where we have a question before us that's based on an actual situation. But I also just want to be clear.
Well, there
from
is
the
an
very
actual
that
situation. There isn't, if I may interrupt,
sorry, go ahead.
if I may interrupt, there is an actual situation. I just cited it to you. There's a member of the MTA board who's subject to our jurisdiction, who's also involved in the rollout of the vaccine. Now, my question to you is, does the executive order entirely exempt this individual from our jurisdiction?
And I believe I've answered your question in general terms as to how I understand the executive order operates. But as you know, we are not going to discuss any individual specific situation during the public session. And as counsel, I am not going to advise the commission on legal interpretation of an application of that law to specific individuals during the public session.
Yes, I respect your position. On the follow-up, however, have you actually discussed this issue with anyone in authority in the executive chamber?
Have I discussed the issue of whether or not somehow the executive order exempts other state officers and employees from being subject to the public officers law and their regular state duties? Is that your question?
Yes.
I have not had that discussion because, as I've said, there is nothing on the face of the executive order to make me think that that is the case. It is on its face limited to COVID-related duties. If you want me to ask that question,
if I may plow some old ground, Mr. Chairman, has there been any discussion with the executive chamber by our staff with respect to the executive order?
Not recently. When it was first issued, I believe we did have some discussions in context of very specific questions that came in relating to specific individuals.
And with whom was this discourse conducted?
It would have been lawyers in counsel's office.
Who are the lawyers?
I don't specifically remember who I had the discussions with, but really, for the most part, my communications generally are with two lawyers in counsel's office, Judy Mogul, Julia Kupiak. Occasionally, I speak with other lawyers, or other lawyers may join them, but for the most part, those are the two individuals I speak to in the chamber.
Well, Ms. Mogul is special counsel to the governor, correct?
I don't actually know her title.
What does she is, so far as you're aware, within the ambit of her responsibility is the panoply of ethics issues, or does somebody else handle it in the executive chamber?
I don't know everyone that they've assigned to ethics issues. So I can't really answer that question, but my understanding is both of the individuals that I named deal with ethics issues. Other staff may have contact with other lawyers from time to time, because like I said, there's been other lawyers who have handled ethics issues, but these are the two that I deal with on ethics issues.
Yes, and I want to be very meticulous about not mischaracterizing or misstating your conclusion, but in my words, and then you can correct me, of course. So far as our staff analyzes the legal situation, someone who's in a dual role, serving on a state board and also volunteering in response to Corona, is not exempt by the executive order with respect to the ambit of their involvement in the state board. Is that a fair summation?
Could I make a suggestion?
Sorry, go ahead, Commissioner.
And with all due respect, we've been, I think this line of questioning or discussion is so far off the proposed regulation, and we've been through this executive order issue a number of times. Just in terms of our time and what we have in our agenda, I wonder if this discussion, if it's going to happen again, if it could just happen offline.
Thank you very much, Commissioner Deering. Nonetheless, I'd like an answer to the question I just posed. Is the summation that I articulated your view?
Yes, you've articulated my view, but to the extent that, you want me to confirm that that is how the chamber reads it in a general way, I could certainly convey that question.
Thank you. Mr. Chairman, may I follow up?
Yep, Gary, but let's keep this brief, okay?
Well, I'll keep it brief, consistent with what I believe is my responsibility of due diligence before I vote on this proposal.
Absolutely.
Let me put the question to staff. Are informal or formal opinions of the commission or commission staff within the ambit of this proposal?
No, they are not. The records access regulations do not cover disclosure of informal or formal opinions.
Why not?
Because this is about the records access process by which members of the public request records that are publicly available. And informals and formals are not subject to that process. The commission, as we've discussed at length over the last several meetings, makes determinations about publicizing formal opinions, and they're posted on our website. And as you know, the subject of how the commission wants to treat informals is a matter that's being taken up by the confidentiality committee, and we'll continue that discussion on the February 10th meeting. But certainly it wouldn't be dictated by this process whereby Walt is turning them over. If an informal were decided by the commission to be able to be made public, that would be done by a vote of the commission and not through the records access process. This is a process just for being able to request publicly available records. It is not for something that is done separately at the discretion of the commission.
With respect to formal opinions, and the formal opinion by definition is one that is in writing and adopted by the commission, correct?
Yes.
Are they accessible to the public other than on our website? In other words, if somebody called up and said, I want a copy of any informal opinion on this particular subject, what would the response be from staff?
I mean, Walt, you can answer, but I assume that Walt would just send them the link.
Correct. For any formal opinion that's already on the website, I would just point them to where it is on the website. There wouldn't be a need to send a separate document.
Let me now move to the question of the financial disclosure statements, if I may, Mr. Chairman.
Go ahead.
At the risk of plowing some old ground, let me see if I can get a summary. The current policy is that if an inquiry is made, the filer will not be made aware and cannot be made aware even if the filer asks if an inquiry was made. Is that correct? This is the current policy I'm addressing.
Yeah, Commissioner, this is Martin. That's correct under the current regulations. Obviously the draft would expand that briefly.
Right, and this policy was never adopted by the current commission. The staff's position is that, if I understand it correctly, and again, you'll correct me if I have it wrong, is that it was the policy of a predecessor commission, and that the current commission implicitly sanctioned it by adopting the records access policy that is now before us for amendment. Is that correct?
No, actually, that is not correct. The records access regulations that have been in effect by this commission, which were voted on by the members of this commission when they were initially promulgated in, I think, 2012 or 13, laid out what was publicly available. And as I mentioned previously, that tracks with 9419 of the executive law, which provides that the FDS itself is publicly available. As we've discussed today and before this proposal would be to let someone know if someone had requested their FDS, but nothing beyond that.
Yes, very helpful. On the follow-up, the current policy, which is what I'm addressing at this juncture of the discussion.
The current regulations.
The current policy, however, prohibits a filer from being informed if an inquiry has been made with respect to the filer's FDS, correct?
The current regulations provide that an FDS is public and nothing else about the FDS.
Right, but the implicit policy that an inquiry will not be divulged to the filer is a holdover, staff would say, from the predecessor commission. But
no, and I don't know how many times
by the current commission.
Gary, I don't know how many ways to keep saying this. We have certain public information. The FDS is public. Nothing else about the FDS is currently public. That was a regulation that was voted on by the 14 members of the commission in 2012 or 13. I had to look up the date. That is the regulation. There's no policy to speak of.
All right. Now, with respect to the current policy,
there's no policy.
With respect to the current policy, as you've described, if another commissioner asked if a colleague's FDS was scrutinized, what would the response be to that commissioner?
I'd have to know what it was about and why they were asking, but I think you have the gist of what's going on here. So, you know, the regulations provide that we would disclose to a filer that their FDS had been requested. If you would like the regulations to provide additional information, the commission should discuss that. But I don't think backing into an answer, as you're trying to do, is the most productive use of all of our time. So I think the commission should decide if there should be additional information, and if there is, we can amend the regs. But we have no policy. This isn't a staff determination. This was a vote of the 14 members of the commission at that time.
Right, but in the hypothetical, if a commissioner made an inquiry about another commissioner, the staff would say that is confidential?
I'm not going to answer that. I think the commission should discuss whether it wants to add additional information to the regulations or not.
All right, on the follow-on, similar question. If an inquiry was made about the FDS filed by senior staff, somebody on the staff obviously knows that that inquiry was made. Would it be kept secret from the other staff member, or would the staff member be told that the inquiry was made?
Again, I'm not going to answer that hypothetical question.
Thank you, Mr. Chairman. At the appropriate juncture, I hope you'll entertain some amendments to the regs.
Thank you, Commissioner. Okay, so let's go back to the regs. We need a vote here. Can I have a motion to approve?
Mr.
Well,
Chair,
when do you want to entertain the amendments? Proposed amendments.
Hang on one second. Commissioner Weissman, go ahead.
I just, I'm a little confused. If I understand what Martin said, that under the regulations, if a filer has a filer's information, whoever requested that information can be obtained under these proposed regs. Is that correct, Martin?
The proposed regs would allow a filer to know if someone had requested their FDS. That is all they propose. Again, this came out of the committee. This was not a staff proposal.
And that would only go to who requested it, which is anything else beyond who requested it.
No. In fact, it would go only to whether or not it had been requested, a simple binary yes or no.
Is that so is that different than how the how FOIL is applied throughout the other agencies in the state of New York subject to FOIL?
It's my understanding that requests for information under FOIL, the requests themselves are public as a FOIL log. But you have to go agency by agency.
Well, it could either be a FOIL log, or if an agency didn't hold a log, but came in as an email, a piece of paper, a carrier pigeon, whatever, as long as it falls under the definition of a record, it would be released. But other personal information other than the name might constitute an unwarranted invasion of personal privacy under FOIL. So, address, phone number, that wouldn't be released, and that would make sense.
Sounds like So
our regulations only get part of the way there.
if we were subject to FOIL, they would only get part of the way there, correct?
Okay, thank you.
Mr. Chair, if I could explain my vote.
We haven't taken a vote yet.
Okay.
Well, again,
So,
Mr.
if I could speak on the motion.
you would direct me when
Hang on, Gary.
proposed.
Commissioner Levine, 1 second. Commissioner Yates, go ahead.
All right. I'm on the subcommittee and for confidentiality, and I might have been prepared to vote for this, but I'm going to vote against it right now, and I'll tell you why. During this public session, 2 different staff members were asked a question by a commission member, and both of them said they weren't going to answer. Now, it could be that that's either required by law or respecting confidentiality, in which case it should be taken up in executive session. But when the commission member asks a question that's pertinent and relevant on a pending motion in a public session and is simply told by staff, I'm not going to answer that, my vote is no.
Okay, well, thank you, Commissioner. When we get to the actual vote, then we'll record your vote as no.
Okay.
To it. Commissioner Levine.
Yes, you have 3 amendments, Mr. Chairman.
Okay.
When you're ready.
I'm ready.
Amendment number 1. All formal and informal opinions rendered by staff or the commission should be within the ambit of this records access policy. Specifically, with respect to informal opinions, all informal opinions shall be publicly divulged, redacted form if appropriate, and all informal opinions will state that the informal opinion is not binding on the commission. That's
Commissioner
amendment
Levine,
number 1.
thank you. Can I interrupt you for 1 second?
Of course.
Are these amendments that you are proposing here effectively sort of jumping the gun on the confidentiality committee process? I mean, we've had a discussion about this on the subcommittee, and I thought we had agreed that we were continuing those discussions in February with the hope of bringing something to the February commission meeting. And I'm just wondering whether the amendments that you just proposed and are about to propose are somehow jumping the gun on all of that, in which case I would ask you to reconsider that, because to the extent the answer is yes, I will tell you that I cannot vote in favor of them, even if I might like to ultimately, before the confidentiality committee has finished its work. But maybe I'm misapprehending what it is you're proposing here.
Well, as always, Mr. Chairman, when you speak, I listen. So I will defer the amendment, which actually has two parts, with respect to the informal opinions and the formal opinions, to the discussion of the committee. But if I may now go to the amendment regarding the FDS. As I understand it, there has been a final determination in the committee that this reg as proposed is not to be the subject of any further discussion in the committee. If I'm wrong, please tell me.
I think the committee's free to bring up any subject it wants.
Yeah, that would.
Well, let me propose the amendment, Mr. Chairman, and then you can advise. I propose that, to be consistent with all other agencies that are otherwise subject to FOIL, and be consistent with the New York City Conflict of Interest Board, that this proposal be amended to provide that any filer may request, if an inquiry has been made and the individual or entity making the inquiry will be divulged to the filer. There is no principled reason why we should be an outlier. Nobody else that I'm aware of does this. Now, if you want to tell me you want to put that back into the committee, that's fine. I think then you need to hold the whole regulation in the bank.
Well, before we get to that, Monica Martin, is that correct? If we put that issue just raised by Commissioner Levine back to the confidentiality committee, do we have to hold off on the amended reg?
If you were to, I think the.
Well, I mean,
Go ahead,
I think
sorry.
the issue for the commission. Sorry, I think the issue for the commission is, I mean, the committee's already taken up Commissioner Levine's second amendment, and I don't think there's further discussion on that topic. I think it's ultimately a commission decision whether it wants to disclose the identity of individuals who request financial disclosure statements or not. But the first issue that Commissioner Levine raised is still subject to discussion of the committee, and if some commissioners would like to incorporate that somehow into records access regulations, then we could certainly table this for that discussion. And to the extent Commissioner Yates is concerned that some commissioners haven't been able to get their questions answered, certainly commissioners could call us between meetings to get their questions answered. My reasoning for not answering questions was, to me, they were delving into legal opinions that should be only handled in executive session. And if commissioners want to pursue it further, I'm happy to entertain that in executive session. But I think that it's really up to the commission if they want to defer these regulations for further, committee and confidential discussion, then that's up to the commission.
And Commissioner Chair Rosen,
Yeah,
I might clarify that all I was trying to enunciate to Commissioner Levine was that there may be reasons why staff would need to know where a certain FDS was requested, but we don't, as a practice, Walt doesn't inform us if someone requested our FDS. But I can't tell you what we would do in a particular situation, or what we would do with response to a commissioner who asked for another commissioner's FDS, because there could be business reasons why they need to see it, or it could be personal. I don't know the answer to that. And so that was my reticence in speaking.
Understood. Thank you. Am
If
I,
I may, Mr. Chairman, if
Go
I
ahead.
could elicit an articulation from whoever's propounding this regulation. Why is it that the Joint Commission on Public Ethics should be the outlier? No one else withholds this information. Why should we? What is the rationale for this proposal?
So I don't necessarily think it's accurate to say that we are an outlier. Our law does not make this information public. FOIL makes it public. We're not subject to FOIL. For the Conflicts of Interest Board, the city charter makes it public. We're not subject to the city charter. They have legal requirements to make it public. For the past, decades of this entity and its predecessors, a decision has been made not to make this information public, not to make public something that isn't covered by the statute itself. I can certainly think of policy reasons for that. Among others, is protecting the public's ability to request this information without fear of reprisal. The purpose for why the financial disclosure statements are created is very different than how FOIL records are created. Financial disclosure statements are made purely for the purpose of making information public so that people can be confident in their government about potential conflicts of interest. These records are meant to be public, whereas FOIL is allowing the public access to general business records that go under a review to consider whether or not they can be made public whenever there's a request, to look for whether or not any of the exemptions apply, whether or not there's information that shouldn't be made public for various legal reasons. Very, very different policies and operations and how they work. The reason that you could consider not disclosing this information is to protect individual members of the public from fear of reprisal. We don't want to discourage people for asking for a record they have every right to request. Now, again, I said I don't think we're the outlier because as we've advised, we've looked at other states and other municipalities across the country, not extensively, but we've looked at some, and the practice varies, and the laws vary. So we are not the outlier, but this commission has taken this position to put the interest of the person requesting the financial disclosure statement over the interest of the public servant in the past and not change what the law requires. If the commission feels that that policy is not the policy that they want to adopt and they want to change it, the commission can change that. And again, we can.
Right, but the rationale of the governor's executive order exempting volunteers is precisely diametrically opposite to the proposition you've just propounded. In any event, I want to ask this question.
This commission has a different mission, different policy statement. We didn't issue the executive order. The reasons for the executive order, to me, seem clear on their face, but obviously the governor's office can speak for itself, but there was an emergency and they needed fast resources. To me, you're talking about apples and oranges. I don't really understand what one has to do with the other. We're talking about disclosing to a public servant who requested their FDS. And I would ask the question, why does the public service need to know who requested their FDS when the public servant is well aware that when they disclose this information and they take on their job, their information is going to be publicly available? But again,
yes, if I may, just as a general proposition, is it fair to say that the commission can exercise the prerogative to divulge any information or any document that it deems appropriate to divulge unless it is specifically prohibited by the statute? Is that a fair statement?
I think that's correct, and that is in part what these regulations are intended to do is with respect to records that have to date been sort of not public. The commission, if they move forward with the records access regulation changes, would be making more information publicly available. I think we've lost everyone on camera. We're having okay, it looks like everyone is back, technical difficulties. So yes, I think there is information that the commission could vote to make publicly available through these regs if it is not deemed confidential under the statute.
Mr. Chairman,
Yes.
thank you very much, Madam General Counsel. Mr. Chairman, what's your pleasure? You want the whole discussion, including the vote postponed pending the committee meeting, or I will put forth the amendment today? It's up to you.
Well, let me just ask a question here. I don't necessarily see it as an either or, Commissioner Levine. I see a third option, which is that we vote on the regs as drafted today with the understanding that in the confidentiality committee, we can make changes, which we can then implement. And so I don't know why we have to hold up voting on the regs today on things that we can otherwise change if we want to in the future. These have just been policies of the commission. We can change the policies if we want to. That's one of the things we're debating.
Well, if you're going to vote on the reg today, then I put forth my amendment, if you please.
Go right ahead. I would like us to vote on the regs today. So go ahead and put forth your amendment.
I've withdrawn the First Amendment, but the Second Amendment I'm not going to withdraw. And I propose that the reg be amended that if an inquiry is made, the filer can request to know who made the inquiry.
Okay, so I'm going to assume, Commissioner Levine, that's a motion to approve the regs with that amendment, right?
Yes.
Okay. Is there a second for that?
Mr. Chair,
Yes.
I'm
Commissioner
going, I'm going to second that because part of the discussion here regarding fear of reprisal, believe me, in the business context, when competing entities seek information that's come into state agencies, as someone who was involved for many decades between 2 and 3 regarding FOIL matters, the fear of reprisal is considerably much greater in the context of commercial or trade interests. And I just can't understand part of the argument being made by our general counsel. So and it's consistent with everything else in the FOIL world. I understand we're not subject to FOIL by law, but we are trying to be transparent. So I'm going to second Commissioner Levine's motion.
Thank you. Martin.
On the motion, Mr. Chairman, on the motion.
Yes. Yep. Go ahead.
General Counsel and Deputy Counsel have said that we are different from FOIL because we are prohibited by law from acceding to these kinds of requests as to who requested. Can you just point to me where in the executive law that prohibition is stated?
Commissioner, I'm sorry, I didn't say we're prohibited. I said that our statute specifies exactly what records are publicly available, and it exempts us from FOIL. So FOIL does not apply. And then Commissioner Levine asked me some more questions, and as I believe I said in response to that, this question is completely in the discretion of the commission. There is no law that would prevent the commission from changing these regs to disclose the identity of an individual who requests an FDS. It's just the commission would have to change the regs. There's no law that prevents it.
I was only trying to have you point to the statute that either permits you to do it or doesn't permit you to do it. It would be helpful if I knew or we knew what law we're talking about, because the reference to it is made repeatedly.
94, Executive Law 94-19 makes clear what records are publicly available.
And where does it make clear that the requested amendment cannot be accommodated?
It doesn't. As I just said, the law does not The law does not
What language in
prohibit.
section 9? You allow me to finish. What language? What specific language in section 19A are you referring to? It's a large section with many subparagraphs.
Okay,
you
I'm not
point that?
sure. 9419 identifies the specific records that are publicly available. And then in 2012, this commission adopted or modified the records access regulations, which allows staff to respond to records access requests. And the existing regs are only allow staff to produce what is identified in 9419A.
Okay, so
And
I
that
take it
is
you're relying on the language in the statute that says the only records of the commission which shall be available for public inspection. Is it that language, the only records?
I am relying on that law and the regulations that the commission adopted, which we now follow. The commission has complete discretion, as we've discussed, to make more records that are not publicly available, as long as they're not confidential. And that's the purpose of these amendments. There are several things that are now in the proposed Part 937 that are not included in 19A that the committee is recommending now be made publicly available. And if the commission chooses to add in the identity of someone who requests an FDS, then staff will then be able to make that record publicly available.
Okay, you've
But there's
answered my
nothing in the
question.
law that prohibits it.
Mr. Chair.
Yes. Commissioner, go ahead.
I don't want to cross talk, but I have a question of the maker of the amended motion, that is Commissioner Levine.
Go ahead.
All right. And number one, previously I said I was going to vote no because I thought that your questions, while relevant and pertinent, had gone unanswered. But by your motion, I take it you feel satisfied with whatever answers you've been given, so that we can go ahead and proceed on this. Is that correct, Gary?
Thank you, Your Honor. My position is that these issues were to some extent, to a great extent, milled over in the committee meeting.
Okay.
A number of these questions were posed, and the staff's position has remained the same. And I have no particular criticism to make of the staff judge, but my position is that there are a number of these issues that we've considered in the committee in which the institutional prerogative of the commission and individual commissioners is being circumscribed. And I believe as an institutional matter, that's simply inappropriate and not in the public interest.
Okay. Then
so this skirmish today is part of the overall discussion about who's in charge here. And it should be the commissioners.
Okay. Now, Commissioner Levine, if you don't mind, I have a friendly amendment to your amendment. And that's the following. That's the following. The current regs lay out what the statute says should be made available, which is fine. The proposed amended regs delve into the area of things which the commission has the discretion, because it's non-confidential, to disclose as well, which is fine. And I don't have a problem. I'm sorry, I don't have a problem with that in concept. But the one caution that I would make is that Section 87 of the Public Officers Law, the Freedom of Information Law, also has some exceptions that when an agency is about to disclose a public record, that there can be an application under certain conditions that it not be disclosed. And if you look at 87, it talks about things like an unwarranted invasion of privacy or interfering with law enforcement investigations or judicial proceedings, or depriving a person of a fair trial, et cetera, et cetera. So my friendly amendment to your motion would be that if we're going to voluntarily, as an agency, disclose things which are not mandated to be disclosed by 94, but which we have the discretion to disclose, we should apply the discretionary factors of FOIL, which means that I would attach to your amendment subdivision 2 of section 87 of the Public Officers Law to say that the commission or the staff acting on behalf of the commission can deny a request for that information if it's an unwarranted invasion of privacy or any of the other factors that permit exclusion under 87 of the Public Officers Law.
I'm in total accord, and my amendment would have been deficient without your addendum. Thank you very much, Your Honor.
Anybody else want to be heard on this?
I believe, Mr. Chair, I believe I go with the seconded because that's how I envision this being applied in the first instance anyway.
All right.
This is Fisher. I'd like to ask for an opportunity to discuss or debate, and I'd like to offer my reason for choosing to vote against this. I believe there's a very real issue around whistleblowers, and I think that almost by definition, this financial information is designed for whistleblowers to perhaps obtain in the course of their whistleblowing. And we have no way as it stands to protect them from retaliation. And if the effect of this amendment, and I think this is the effect as I understand it, is to make the identity of a potential whistleblower known to the person who files the report without us having any way to protect that potential whistleblower, I think there is a potential for damage to that individual that we would not want to see. So if I understand that correctly, I plan to oppose this amendment on that basis.
Thank you, Commissioner. Let me just make clear something here, because there's been a lot of back and forth. So the staff don't have a position here. The staff are just conveying all of our positions. And so we, as the commission, have the power to change any of these anytime we should determine to do so. So I am going to also vote against, since we now seem to be voting before we vote. But I'm also going to vote against, not because I'm not open to having further discussion about this, but rather because I think it is jumping the gun on the subcommittee's work, which I don't think we should be doing at this juncture. So that being said, Martin, we have a seconded motion, so let's take the vote.
Mr. Chair,
Yes, Commissioner Weissman.
I'm sorry to extend this, but I do want to respond to Commissioner Fisher's observations. Unfortunately, the cat is already out of the bag. For example, under FOIL, if somebody requests time and attendance, and they're in a whistleblower situation, they can obtain it. And their identity can also be determined if somebody were to foil that. So again, I listened to these arguments, dealt with FOIL for, as I said, a number of decades. You know, it may be best for staff to provide all the commissioners with a better understanding of how FOIL works, so everybody at least is legally on the same page before we start voting for reasons that may or may not be grounded in law. But that would be my suggestion. I guess where I'm going is maybe we should be tabling this thing till we have a better understanding.
That I can agree with, Commissioner Weissman.
If you would like that motion, I will make it if you will second it.
I will second it, and you know I'm not generally in the vein of moving or seconding. I'm just calling the roll, but I will second that motion, Commissioner.
Okay, thank you.
I don't think we don't need a motion to table the amendment. If Commissioner Line just withdraws his motion, that should be sufficient.
Commissioner.
And then we can,
Well,
if
do
the
I
commission wants to
understand
adjourn- if the
correctly
commission wants
what
to
is,
adjourn this- Yeah.
do I
Go ahead,
understand
Commissioner.
correctly what is being proposed is that we vote on the proposal as presented, unamended, and that any amendments, plural, will be held in abeyance. Is that what's being proposed?
Commissioner Levine, this is Commissioner Weissman. My motion is to table this whole thing and have staff give the commissioners who haven't lived in the FOIL world before a better understanding of how it actually works, because I believe we all want to get to the same point, which is to become as transparent as we can and hopefully to get this agency to do what FOIL generally requires other agencies to do. But I'm not sure we all understand what FOIL requires other agencies to do.
Right, but is your proposal that we vote on the reg today and hold all amendments in abeyance, or hold the reg in abeyance?
Hold the reg in abeyance till we all know.
Are you sure, Mr. Chairman, that that was the motion that you thought you were seconding?
Yes, look, I am, unless Martin or Monica chimes in here and says that there is some reason why this reg needs to go to a vote for approval today and can't wait until February, then yes, I agree with Commissioner Weissman.
I withdraw my amendment for today.
There's no reason it has to go forward.
Okay, so then, anybody else want to be heard on this? No. Good.
I would just for just one sentence or two. Gary has asked many times for the reason why we ought to be a so-called outlier. I'm still trying to figure out if, as Monica has said, the law allows the request of Gary to be put into the reg. I can't figure out why all of the opposition. Why do we need to be different? Why can't the identity of the requester be a part of this reg? Now, I understand that Commissioner Fisher took a stab at that, but that his view of the law may not be right, as Commissioner Weissman points out, which brings us full circle back to the question that started this all. And if we're going to put this off for a while, I would hope someone focuses on giving us all, at least me, an answer. Why must we be different? Why can't this information be provided by staff? Thank you.
Thank you, Commissioner. All right, anybody else? Okay. I believe this takes us to item 5 on the agenda. Do we have new and other business to discuss? Monica, Martin?
It's up to the commissioner if there's anything new.
Commissioners, anybody have anything they want to raise here? Okay, then I need a motion to enter into executive session, please.
I'll move.
Thank you.
Adjourn.
Second.
Fisher seconds.
Thank you, Commissioner. Martin?
On the motion to executive session, all in favor, please raise your hand. See Commissioners Rosen, Weissman, McNamara, and Deering, and Yates. Thank you. I'll call the remaining roll. Commissioner DePiero.
Yes.
Yes. Thank you. Weissman, Yates. Commissioner Cohen.
Yes.
Come back. Commissioner Levine.
Yes.
I seem to have lost my feed. I'll wait a second.
Okay, so Martin, I don't know if you heard, but Commissioner Cohen and Commissioner Levine both said yes. Commissioner McCarthy,
Yes.
1, 2, 3, 4, 5, 6, 7, 8. Who are we missing?
Commissioner Jacob.
Commissioner Jacob?
Yes. Yes.
Okay. I'm missing Commissioner Hortz. I have 11, I believe.
Okay.
Martin?
Yeah, sorry, I lost everything. Let me just finish this up. Commissioner Levine?
He said yes.
Martin, we already, Monica completed the vote.
Great,
11, yes.
thank you.
Motion carries. Okay, public session is adjourned.
Please stand by. We're back in public session.
Okay, thank you very much, Walt. I'm going to ask General Counsel Monica Stam to report on our executive session.
Sure. During executive session, the commission discussed litigation and personnel matters and authorized steps in several approved one settlement agreement and a modification to an existing settlement agreement. And the commission authorized steps in several investigative matters, closed 2 matters, and discussed other investigative matters.
Thank you very much, Monica. Is there any other business before the commission?
Not that I'm aware of.
Hearing none, may I have a motion to close the commission meeting in public session?
I'll move. Gearing.
Second.
Second, thank you very much, Jim Yates. All in favor, please signify by saying aye, raising your hand.
Aye.
Aye.
Commissioner Weissman, Yates, Fisher, McNamara, and Deering. Commissioner Cullen?
Yes. Yes.
Commissioner DePiero?
Yes.
Commissioner Jacob?
Yes.
Commissioner Levine?
Yes.
Judge McCarthy?
Yes.
That's fine.
Motion carries.
Thank you very much, Martin. To all, have a very good afternoon. Take care.